Okay, we're live. This is Attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. And I'm joined by some very special co-hosts and a special guest. We have co-host Miss Cassandra Woodard. Cassandra, how are you today?
I'm good. How are you?
Okay, good. You kind of froze there for a minute. Didn't hear you. And we have,
Working on it.
okay, no problem. We have the infamous Miss G, Georgette Truan. Hi, Miss G. How are you?
I'm good, thank you.
Good. And looks like we have a very special guest tonight, Tatiana Navarro. Did I say that right?
You certainly did. Good evening, Mr.
He's a
Davis.
returning guest, Mr. Davis.
A returning guest. You've been on the show with me before, Miss Navarro?
I certainly have.
Okay, how long ago was that?
Thank you for asking. I believe that I originally came on in October of 2021.
Oh, okay. That's been what?
It was October, yes, 2021.
That's been at least a year.
Thank you. Yes.
Okay. What's been going on in this year time frame?
Oh, thank you so much for asking. Greetings to you, to your listeners, your supporters, to people near and far who are experiencing the worst pain in the entire world, which is the pain of separation from your children. Good evening, Miss Georgette, and your your co-host. Again, thank you so much for inviting me on your show. What's going on now is, just to quickly recap, in May of 2021, I have a, pardon me, 10-year-old grandson who was taken into DHS protective custody in Philadelphia. We call Child Protective Services DHS here in the Philadelphia area. He was originally placed with me for kinship care. Then 6 weeks later, his mother kidnapped him from me, and I was actually never able to get him back through the DHS process. However, I will give credit now to my new attorney. One of the reasons I'm coming on your show is to, of course, share what happened and be able to get some tips on ways that I can better work with counsel. I had a lot of lawyers who just didn't get the job done after Jaden was taken from me. And at last I found Mr. Mark Keenhill, who's working with me now. I'd like to give him credit. Mr. Keenhill filed custody petition through the custody portal for me to get custody of Jaden, my grandson. He was eventually discharged to his father, but I still wanted to support him in custody. And I'm pleased to announce that about 3 weeks ago, we went to custody court. It was a long day. There were a lot of cases. We were waiting around. Jaden's dad came, and Mr. Keenhill was able to strike an agreement with Jaden's dad for custody. So the court awarded me partial custody. And the whole thing was very cordial, very warming. So the Friday before last, Jaden came to visit me for the weekend. The partial custody allows for weekend visits from Fridays after school until Sunday evening. So I'm just delighted that he is back in our lives. We had Christmas, we had an extravaganza. So we were in court and we were able to certify the agreement, but we were actually able to arrive at the agreement before we got before the judge. So that's been a very remarkable outcome after more than a year. What's happened to bring me back on the show is my infant granddaughter. My daughter had another baby. The baby is now about 5 months old. She was born in May. My daughter began to run from state to state between Pennsylvania, Delaware, and New Jersey when she was about to have the baby, because she was aware that since she just had a dependency matter with Jaden that had been closed, that DHS was probably going to come looking for her to take the baby. On August 23rd, 2021, I got a phone call, one of many from DHS, informing me that they had the baby at Einstein Medical here in North Philadelphia. They asked me if I would resource the baby, of course. So I stopped what I was doing. I ran over there, and DHS literally gave me the baby physically in the parking lot of the emergency room. I signed the kinship intake papers. They informed me that the baby's mother, my daughter, had undergone the second, or I should say, another involuntary 302 psychiatric commitment. She was discovered at a CVS pharmacy public bathroom in what the Order for Protective Custody describes as being in a catatonic and unresponsive state. The police then, of course, I'm assuming somehow she was transported with the baby to the hospital. The baby was apparently fine. I brought her home, and it was all bliss for the next 4 weeks. The circumstances surrounding her and Jaden were just eerily similar. During those weeks, I began to ask, well, within the first 24 hours, I began to ask for the 3 instruments that I know are necessary for me as a kinship caregiver. That would be in Pennsylvania, it's a 426330 shelter award letter. It would be the kinship or shelter order, shelter placement order. It would be the kinship award letter that comes from the city that has city letterhead that actually names me and gives me the authority to resource the child for medical and education, and there would be a safety plan. At first, I was told by the DHS workers, now here, after DHS takes the child into custody, they hand everything else over to a third-party agency that they subcontract with. Those agencies are called community umbrella agencies. We call them CUA or CUA for short. So kind of DHS just steps away, and then your CUA worker steps in, and they are assigned based on police districts where the parent lives. And in this case, it was the wrong assignment. It was just, we should have had that CUA agency, but we still had them because that was the last known address of the mother. So as it turns out, we got the same worker that we had last year that was responsible for taking Jaden from my custody and care. I was told by the staff members at first that my kinship had not been approved. And I decided to do my very best to be really quiet, to use baby words, and not to ask any questions, because last year was horrible. So I used baby words and said, oh, please, can you give me some kind of a little letter to show that I have the baby so that I can get the baby to the hospital? I didn't say my shelter order or anything like that. And at first I was told, again, I'm sorry, I'm repeating myself, that my kinship had not been approved. I knew that was a lie. As you and I all know, the shelter hearing has to occur within 24 hours of taking the child into custody. That is the law. I know that hearing happened. I know that the baby was assigned to me, and I know that I should have had hand delivery of those 3 instruments within 72 hours. But I went along with it. Okay, hasn't been decided. Well, how about tomorrow? Well, how about the next day? Eventually, the staff told me that this supervisor, I don't know if I can name her, but I can say the agency, it's called Turning Points for Children. And the supervisor informed me that she was not going to give me the kinship papers because she planned to take the baby, and she never did give them to me. So I'm going to get that baby. I'm going to take that baby. So you can't have those papers. We had, and then I'm so sorry. It's hard for me to keep this story in a neat time frame, fact pattern. This was August 23rd again when the baby was placed with me. Going back just a little bit, on August 2nd, my daughter was in my home with the baby, staying with me for a little while because she had run out of time at the shelters that she was staying with. There was a verbal altercation. I called the police. The police had to have her removed. I consulted the elder abuse hotline and the senior law center. They advised me to get a protection from abuse order. I went to court. I did that. I had started that process early in August. This was before the baby was placed with me. I did go to court. I was awarded a temporary, we call it a PFA, and the PFA included the protection of full physical and legal custody of Jaden and Carly. the two younger grandchildren. I'm already raising the 21-year-old grandchild. So these are three children that have been taken from my daughter. And I thought that was wonderful. So I was also automatically assigned, or the baby was assigned, a child advocate from the county. Whenever there's a PFA, that's part of the protocol. The advocate informed me, to my delight, that because of the PFA, I would not have to attend the family visits with the mother. I dreaded that because I knew that something abominable would happen, something horrible. Every exposure to her is detrimental to all of us. She has a history of violence, assault against, and arrest and conviction for child abuse, child assault, and that kind of thing. And in this case, she had threatened to poison the baby. You see, the psychological factor here is that in my daughter's mind, in her mind, she is a capable, loving parent. And in her mind, I am not. So in her mind, if she can manipulate the system so that the child is taken away from me, she can manipulate the system so that the child is re-awarded to her. So she wanted the baby in foster care, just like she wanted Jaden in foster care. And she had warned me that she would either snatch the baby, like she did Jaden, and blame it on me, or she would poison her food during the family visit. I could do that, she says, right in front of everybody. I'll poison her. I'll make it look like you did it. I'll make you look bad. I get the baby. Pardon me. The child advocate informed me that because of those circumstances in the PFA, we didn't have to have the family visits. The CUA agent, however, upon hearing that, contacted the child advocate in my county. By the way, I reside in Montgomery County. The dependency action is in Philadelphia County. They're bordering counties. The CUA agent was enraged when I told her that we didn't have to attend these family visits and she would have to find other ways, to go about, the order, to accommodate the order. For right now, the goal is reunification. She then contacted the child advocate in Montgomery County. The child advocate then reached out to the court administrator with a request to modify my protection from abuse order and modify the custody. That didn't happen, fortunately. But this co-worker began to stalk me. She sent a worker to my home for no reason and told her to just take the baby. I called the police. The police made her leave for lack of jurisdiction. Then finally, October the 7th, while I was at a children's hospital with the baby, we were in the laboratory getting lab work done. There's a long story to that. And I was just coming out of the laboratory with the intent of sitting down with the physicians, going over her treatment plan. I had requested things like neural testing because of genetic loading in the family. The other two children have autism spectrum disorder, and my daughter's a substance user. And as soon as I walked out of the laboratory in the hospital, there was the DHS worker. She had seen that I was alone. They had been obviously stalking me or tracking me. How would they know that I was at the hospital that morning? Because I was actually scheduled to go at 9:30, but I didn't actually go until 11 o'clock. And in the final analysis, the supervisor was on the phone, instructed me to produce the contents of the baby's diaper bag, which I did, instructed me to show her food, which I did. Then she instructed the worker to take the baby. And she did. And right there on the spot. So I've filed a motion to intervene again. This was last Tuesday on Election Day, and the judge denied the motion to intervene. And here we are.
Did you appeal that denial?
We're in the process of appealing that now. In this case, it's called a motion for reconsideration.
That's something different. So In California, you can ask a judge to reconsider his or her decision if you have new law or new facts. Okay?
Thank
That's
you.
that's
Yes.
generally what a motion for reconsideration. Let me tell you what's not a motion for reconsideration.
Hmm.
Hey judge, I think you made the wrong decision. Will you change your mind? There's no such thing. Okay? In California, if the judge had denied that type of motion, you get to file a writ, which is a special type of appeal, or or you might even be able to file an appeal. In your state, in Pennsylvania, you're going to have to talk to your lawyer about which one or both do you want to do. But you got to get that issue before the next level court of appeals in Pennsylvania. Okay?
Oh,
Yeah.
okay.
So, motions for reconsideration, unless you have new facts or new law, at least in California, they're no good, right? I can't tell you how many times over my career I've seen this, especially in civil cases. The judge makes the decision, and then somebody on the case wants to file a motion for reconsideration. And the first thing the judge says when the hearing comes up is, what's the new facts or what's the new law? And then they start arguing about why the judge made a bad decision, last month. And that's just a fast way the judge will say, bang the gavel, denied. All right. So you make sure that your attorney, explains that. And if that's an issue in your state, I don't know. I'm not a Pennsylvania lawyer. Although one of our lawyers in our office is a licensed Pennsylvania lawyer. She's licensed in California and Pennsylvania. She's from Pennsylvania, and she recently sponsored me to. I'm doing a case in Pennsylvania now, and she recently sponsored me to do this case because whenever you do pro hoc vice and you ask like the foreign state Pennsylvania to let me do a case there, I have to have a sponsor, a member of the bar there. So make sure you talk to your lawyer about that. Okay. I might be talking to her Friday about something, and if I remember, I'll ask her, if motions to reconsider are the same in Pennsylvania as in California. Because if you don't have any new law or new facts, and it's the California rule, you're wasting your time, and you might be missing an important date in which to file a writ, because generally writs have to be done in a very short period of time. There's a general rule of thumb in California that if it isn't a writ authorized by a statute, just a common law writ or remedy seeking some type of appellate review, it's like 7 days or 10 days, something like that. So time may be ticking on you, right? And if it's an appealable order in California, and not all the time, but generally you have 60 days. I don't know what the rule is in Pennsylvania. I was talking to someone recently from another state, and they said, "Oh, Mr. Davis, we only get 20 days." And I've talked to people that say, "Oh, we only get 30 days." In California, you get 60. That doesn't mean it's the same rule in every state you go to, right? So you got to talk to your lawyer and make sure that he or she knows that, or knows what the rule is. I can tell you this, and it's not a good thing, it doesn't replace talking to a lawyer, but you might want to Google it to get an idea,
Thank
right?
you.
But always rely on the lawyer's opinion, not Google. All right. Google knows a lot, but it's not always right. Right.
Of course.
Hold on. I saw her mouth was about to move. Miss G, what do you have to say?
I just wanted to mention something to Lindsay. Uh, she wrote it. She said my caseworker told me that I needed to be reassessed for mental health due to a reaction she had in the courtroom when they took her kids. Cried, was in shock. I don't know how. Um, Basically, they, Lindsay, I just want to tell you, they say this to all the moms that cry over their children. Once you show a reaction as a mother, loving reaction towards your kids, they say they see that as a mental health issue. Even if you don't have drugs, you've never been in trouble with the law, what have you, they see that as negative when you show any type of emotion. And I think I've told you guys several times, that's why I call them narcissistic, because only a narcissist will get a joy from seeing you react towards their corruption, towards their chaos. And when they see that, they see that they have control over you. And I seriously, I don't know if I spoke with you before, Lindsay. I don't remember, but I would love to speak with you after the show. If you can just call the number, the 888 number, and let me know what we can do to help you. I would really appreciate that. The number that you see on the screen. Sorry, that's it. That's all I have to say. She said
Can,
yes, please. So if you
can
see
you
the
guys, can you guys see my pointer on the screen?
no,
No? Okay.
did you
No.
point something?
I was pointing at the 888 number in the bottom right-hand corner.
Right
So
under
what?
Mr. Davis. You can see it right on. Some people don't really pay attention. Yeah, right there. There you go. Under Mr. Davis, the 888 number. Just ask, Lindsay, just ask for a GT or Miss G, and let them know if they can transfer the call to me, and I will pick it up right away. That's all. Thank you.
Cassandra or Miss G, did you guys have any questions for Miss Navarro about her story so far?
I loved Miss Navarro. She's Dr. Navarro, by the way. From the first time I met her, and I remember her very well. I still have her on my cell phone. Um, she's an amazing grandmother. She's very well educated, extremely got her act together. I just fell in love with her, and I don't understand how the system can be so stupid. But then again, I always talk about the system and how corrupt they are. Miss Navarro, you really need to do everything possible to get your grandkids, and it's very important because they need you and they need to learn from you. You're a good role model for them, not the system.
I thank you so much, Miss Georgia. Thank you so much. And by the way, Mr. Davis, I didn't want to interrupt you while you were talking, but Tatiana Navarro is actually my street name. When I was traveling in Central America several summers ago, people couldn't say Tanya, they couldn't say Tammy, they couldn't say my name. So the mother version of my name is Tatiana. And then, of course, they could say Navarro. So that's what's on my emails and things. But my given name is Dr. Tanya Fowler. But I didn't want to hypercorrect you while you were talking. And Georgette, again, of course, you are unforgettable. Your situation too is unforgettable, and you're just a fabulous team. Even though I haven't come before you, I've been watching you guys steadfastly over the past few months. And again, Mr. Davis, you have given us such a gem of knowledge. Mr. Keenhill and I looked over the 388 petition that you had mentioned. We don't have that in Pennsylvania. If only we did.
Well,
But
wait a
just
minute. Wait a minute. I don't know, Cassandra, if you told us about this resource. There is something, and you can find it on Google, that'll take the California laws, and you can look up the similar law in your state. So I know Pennsylvania doesn't have a 388 because that's unique to California. That's Welfare and Institutions Code, California Welfare and Institutions Code, Section 388. But there's something, I will bet a dollar that there's probably something in your state that is similar to that, if not the same. So, Cassandra, was that you who came up with that tool where you could compare similar
It,
laws from state
I
to state?
it it's you can't go on there. Can you and like Put your state, and it will give you a list of how to filter it out.
Hmm.
Do you have the website?
It's the Child Welfare Information Gateway, I think.
Okay, so Ms.
I'm
Navarro,
pretty sure.
the Child Welfare Information Gateway. So you should be Googling that. Okay.
Thank you. Absolutely.
Okay. And you know what, Ms. Navarro? If you and your attorney want to consult with me about strategies to try to implement with respect to your case and getting this child back, you should have him call me, or both of you call me, or call Georgette, and she'll schedule and set up something for you.
Thank you so much. One of the things that I really, really, really
It's
appreciate about
actually,
this.
Go ahead.
You
Someone.
please go ahead.
oh, okay. It's actually called childwelfare.gov. That's the website. You can find statutes and laws for your state.
Oh, thank you so very much. Yes, I was going to say that one of the things that I really appreciate about Mr. Keenhill, he's very unique compared to a lot of the lawyers that I've talked to over the past year. And that is that he's willing to learn, he's willing to look up things, and willing to collaborate. And he's
Good.
very, very humane. And what you just gave me, do you mind if I make a comment about the information you just gave me, Mr. Davis?
Not at all. Go ahead.
That was a gem. That was amazing because Mr. Keenhill, when the judge said that he denied my motion to intervene, he said it's because I lack standing. This was at the dependency hearing last week.
Hold on. Let me comment on that, okay? Because I might forget if I don't say it now.
Sure.
All right. So the motion to intervene, at least in California law, is for a person who doesn't have standing to get into the case. So if the judge says to you, at least a judge in California, says to you, I'm denying your motion to intervene because you don't have standing, that's a non sequitur. A motion to intervene is to give you standing. Of course you don't have standing. If you had standing, you wouldn't need to file a motion to intervene. So I'm hoping that you misunderstood the judge. And if you didn't, Pennsylvania law is way different from California law, which is possible. But I don't know. Look, my first year of law school many years ago, 3 decades ago, almost 4 decades ago, they have a class that you have to take, civil procedure. It's required, I think, in your first year or your second semester or something at every law school in the country. It's a required class. It's like contracts, right? And from state to state, things do vary a little, but there's basic things from state to state.
Yes.
One of those basic things is a motion to intervene. Motions to intervene are filed by people who don't have standing in the case. That's why they file it. If you had standing, you wouldn't need the motion. Okay? You're looking at me like, deer in the headlights.
That makes perfect sense. Well, Mr. Keenhill, I'm sorry, I hope I'm not interrupting you. Mr. Keenhill did find some case law. I have it here with me. I was delighted when I read through this today because the judge said last year, you don't have standing. You get out of here. You don't have standing to intervene. You're not DHS. You're not a parent, and whatever this other entity was. But here is the case law that is discussing standing in dependency proceedings. And it says that this is Pennsylvania. The parents of the juvenile whose dependency is at issue have standing to intervene. The legal custodian of the juvenile whose dependency status is at issue. And finally, the person whose care and control of the juvenile is in question. That's what they have outlined here. And they have a case here where there were family members who were foster parents of an infant, and they wanted to intervene. The court allowed them, or granted their petition to intervene, but then at appeal level, it was reversed because it was decided that they were never custodial foster parents. I think that was the argument here. But when you said new matters, you can bring the motion to reconsider because you're introducing something new. The new thing, I think, in our case would be the assertion that I have custody in Montgomery County. I had full physical and legal custody granted to me. I grant you that even though that was a condition of my protection from abuse order, and it wasn't the custody granted through the normal custody family court portal, after I was granted that level of custody through the PFA, before the baby was taken from me, I went back to court, pro se, and I filed a petition for emergency custody. Why an emergency? Because of her medical needs. And the court instantly granted that within hours. They said, you will continue to have full physical and legal custody. And then they referenced the PFA. So I have two, I guess you would say, two custodies. I don't know how else to articulate that. So when DHS came into Montgomery County and took the baby from me in Montgomery County and never acknowledged my custodianship, we feel that they were in a jurisdictional violation. So we didn't bring up the fact that I have custody to argue for the motion to intervene. So I'm assuming, that's how my mind works, not like a law, that now when we go back with our motion to reconsider, we can say, hello, Mr. Courtman, Dr. Fowler actually has physical and legal custody. This is new to you. She is one of these parties here, I think. I would consider myself to be, first of all, I am a legal custodian. Even though DHS claims custody, I don't think that their claim of custody eradicates my custody. I don't think it works quite like that, even though they want everybody to think that it does. And then number 3, the person who's care and control of the juvenile is in question. My care and control was in question. Horrible things were alleged about me by this worker. She alleged that I wasn't feeding the baby properly. Are you kidding me? She interjected herself in the medical visit at the hospital. I've never experienced anything like that in my life. My field is biomedical anthropology. For 12 years at Temple University, I was instructing physicians, nurses, therapists on how to diagnose with respect to cultures. So the medical interview is my home base. And this woman was so disruptive during the medical visit, interjecting accusations about poor feeding and all kinds of things without ever admitting that she's the person who tried to obstruct me from getting medical care for the baby by not giving me the kinship papers. And she was enraged when I found a pediatric practice that would see the baby without the kinship papers. I was able to triage that myself, and she threatened me and told me, you better not do that. You cannot do that. Thank you for listening. So maybe I'm leaping ahead, but I think that the new information is to inform Philadelphia about my custody in Montgomery County. I also didn't share, one more thing, that I did hire another lawyer. Why? Because she's more familiar with Montgomery County than Mr. Keenhill. Let's just say Mr. Keenhill's Philadelphia, and the new lawyer is Montgomery County. Because the plan is for her to file a contempt in Montgomery County against DHS in Philadelphia because they didn't do what they should have done, conferencing or something, to, I guess, acknowledge my custody. So we're saying that they are in jurisdictional violation by just coming over here and taking the baby.
Yeah, I doubt that they would have jurisdiction in that Montgomery County or vice versa.
Correct. So she's working on that right now. Also, I did apply through the normal custody portal in Philadelphia. the same day of the dependency hearing. The judge said, I can't tell you what to do. I'm not going to tell you what to do. But then he said, go file for custody. Well, we already had the custody petition in Philadelphia. So we're waiting for a hearing date on that. So it seems ridiculous to me to have custody. I mean, in 2 counties. So what I'm hoping is to have my current custody acknowledged
Mm-hmm. Mm-hmm.
and asserted. I mean, how many ways it's sort of like, having to be baptized again and again every time you join a new church. I think the first time it works.
Yeah, it's true.
Okay.
I'm glad I can make you laugh. It's hard to laugh.
I grew up going to Catholic church, and as I got older, I would go occasionally to other churches, other denomination with friends or people that I knew, and it was always an interesting thing, when you first go to the church as a new guest or something like that. That's why I was laughing. Somebody asked me something, and I want to play a quick 1-minute video on something. Oh, here it is. Somebody asked me about hearsay. By the way, one of the things I'm going to tell your attorney, Dr. Navarro, is some things about evidence, because it's not talked about enough. People just want to look at what's fair, or at least what they think is fair, and they haven't discussed the evidence. The evidence is the foundation of every time you win or lose a case. It's the evidence. Or lack of evidence. So here's something about hearsay that I wanted to play for everyone today. So let's watch this. In California, hearsay rules of evidence in juvenile dependency or CPS cases is different than a regular criminal case and different from a regular civil case. For whatever reason, the California Supreme Court and the legislature of California has ruled or made law that hearsay used by a social worker can be used against you in a proceeding. The reverse is not true. You are not allowed to use hearsay in a proceeding against the social worker. Now, there are a lot of exceptions to the hearsay rule, and in California, there's hearsay, which is an out-of-court statement used in court to prove the truth of the matter therein. There are many exceptions, but when you're coming to lay out your case and strategize your case, remember, you have to fall under one of those hearsay exceptions in order to use that important evidence. Call me if you have questions. Evidence is the foundation of your victory, Dr. Navarro.
I wanna share something with the viewers. If it's okay with you, let me know when I can start.
Yes. I mean,
She said yes. Go ahead.
Oh, okay. I'm confused. Okay, so recently Jeremy Kindle, he was a case in Ohio. He was a foster parent, him and his boyfriend, and they took on foster kids, mostly boys only. And he's a 35-year-old. He was sentenced to 94 years in jail a couple of days ago. This case has been going on for a while because the parents addressed, every parent that their children went to that home addressed that the kids are being sexually abused, meaning these two men would have sex with boys and force the boys to have sex with them. The social workers didn't care to hear about the parents' concern. And that's the point I was trying to make. The point that I was trying to make, when the parents addresses concern, the social worker sees that as problem. Well, what do? They stop the visitation. They stop their visitation because they're causing problems. That's why I call the social workers assholes. Pieces of shit. Like literally a piece of shit has more value than a social worker. Why? because this piece of crap doesn't care about the well-being of the child. All they care about is funding, funding, funding. But yet the judges, CPS judges, who sit on the damn bench wearing black robes, would take anything the social worker says, meaning they will take their recommendation no matter what. But then when the parent addresses their concern or cries out for help, the parent is crazy. The parent needs mental health. The parent is not fit to be a mom. But yet you're sending these boys to two gay couples that only wanted boys. Isn't that a fucking red flag? I've been following this case. I just needed to bring it up. It's in Ohio, and he is sentenced for 94 years in jail. I don't think that's enough. I think he should get the death penalty, but that's just my opinion in the matter. And it's disgusting. It's disgusting. It's in Allen County.
Wait a
And-
minute, Georgette.
Yeah.
The case that you're just talking about is an actual case where somebody was prosecuted and sent to jail?
Yes, I'm talking about it right now. Yes, I've been following this case since 2020. He was sentenced recently. 94 years in jail. His name is Jeremy Kindle.
So if I Google it, I'll find that.
I hope so.
Yeah.
Everything is on Google, yeah. Even your health conditions.
It is so grievous. Every word you said is absolutely true.
Thank you.
I taught at Temple University in the School of Social Administration. I'm not a social worker. I'm a medical anthropologist. I was doing medical anthropology there. It's my living testimony. It's my testimony before the God I serve that in 11 years, I did not meet one social worker that I would go to if I had a social work problem.
Oh, I can't
Does
stand
that
it.
tell you something?
Yep.
I mean, the idea of social work is a wonderful idea, but the reality of people who enter that field, as in the case of the person that we're dealing with here, Mr. Davis, you talked about evidence. The supervisor is so, it's hard to describe the level of hate. She's rabid, if you allow me to say that. And the woman actually, I don't scare very easily. I mean, I've lived on the bricks too for a little while here.
It's crazy. Like,
and she had me to the point threatening me every day to take the baby. I'm going to take the baby. You are a problem. She tells me, you're a problem. I am a problem. My daughter was found in a public bathroom in a comatose condition with the baby. But my mental health, you're crazy. Because I, imagine a world where you're in the middle of a medical visit. The baby has a seizure disorder.
Yep.
And the baby was kidnapped before she could even be seen in a consult with a neurologist. But there's something, I'm altered. So the social worker testified. Mr. Keenhill was in the court. I wasn't there. The first 2 times he went, I didn't go because I just couldn't go. I just couldn't be in that courtroom with the GAL and all of these other people that have formulated this opinion towards me, who have no consideration for the baby. In what world? I've already raised my grandson. Shane is in the next room. He's 21 years old. He's a wonderful human being. Then here comes Jaden. So in what world could you conceive of taking the baby from the grandmother? But she testified that I obtained my protection from abuse order to obstruct the family visits. The judge ate that up and issued a threat that if I don't go along with the family visits, then they'll take the baby. The first family visit that I went to at the agency, of course, this social worker made my brother leave the premises. Then she ordered me off of the premises. And then my daughter was, in fact, allowed to tamper with the baby's food, and she was allowed to steal the baby's clothes. That was the first visit. And then the social worker testified in court that I was a threat to my granddaughter because after she was taken from me, I took the whole team, my family. We went to a medical visit. My intention was to see the baby. I sat down with the medical team, consulted with them, explained to them what happened, showed them that I have custody. And I said, I'm not here for all of that, but I want you to really take careful examination of this baby. And I want you, after you take her vitals and do what you do, I want you to order her to be hospitalized in my county for a keener level of examination. And if need be, I want a forensic examination because she's been out of my care. And they were kind of going along with it until the social worker called. They called her, and then the whole thing turned into a controversy. And she testified that I was a threat in court and said all kinds of things. She said that I alleged that my daughter was a weapon.
Yep.
And the judge issued a stay away order against me.
Do you see what I'm talking about? When the parent or the relative raises concern, that they go against that. They don't want you to expose the corruption. See, they want to keep us silent, but yet we pay for their fucking salary. They want to keep us silent. So it really gets to me, and how this bullshit continues. Like, for example, today I had a father and a mother that they had visitation with their 5-year-old, right? The 5-year-old was suffering from stomach pain and had a fever. The monitor in the DCFS office didn't want to call the ambulance, right? So she said, don't worry about it. It's taken care of. So the parents are concerned. They called the ambulance anyways. Did you know that the hospital said had the father and mother not called the ambulance, that child would have died? His appendix ruptured. See, what people don't understand, what the court system doesn't understand is that they need to fucking wake up. They need to wake up. That child would have died in their fucking custody had the father and mother did not do their due diligence. Guess what? They are losing custody because of that call, because they disobeyed the monitor, disobeyed the social worker, and did exactly what they told them not to do, is call 911. But yet it's proven that the child was going to die had they not called 911. You guys understand. I know you guys understand what I'm trying to say. This shit has to stop. And I told you guys before, this shit will stop when you guys start voting these assholes out of office. If you don't vote them out, they get re-elected. And I keep telling you guys this. If you guys don't want to vote, fucking force yourself to vote just to make changes. Make changes. But if you're going to keep them re-elected, then the shit is going to continue to happen over and over again. They are scared more of us than we are of them. That's how it is. But they want to keep you silent using your children, so that way they bully you. So remember this. We are the people. We are the people paying for their fucking salary. Keep that in mind. Start voting. Vote them out.
Dr. Navarro,
Yes.
I want to thank you for being on the show tonight, giving us a catch-up of what's been happening in your case since last year, but it seems like more of the same. I'm not sure why, but I'm anxious to speak to you and your attorney, hopefully give you some insights and strategies to use. Ms. Cassandra, thank you again for co-hosting tonight. And Ms. G, thank you again for co-hosting tonight. And we're going to see everyone tomorrow evening at 7 p.m. Everyone have a good night. Bye-bye.
Thank you all ever so much. God bless you.